Hi there, and welcome again to In Your Corner. Help at inyourcorner.ca, by the way, is the address, the email address to reach out, 1-855-821-5900, or simply inyourcorner.ca for the website to catch past shows and where you can catch our radio show as well. Hello, guys. Good to see you again. Lots coming up on the show today, including top 5 reasons or excuses insurers give for denying claims and what you should do about them. But first, James, take it away, pal.
Well, one of the things we like to do on the show is bring our viewers up to speed on some of the things that they're going to be facing when you have a long-term disability claim. And one thing we hear a lot from people calling us is that they're concerned that the process is going to take a really long time. And another thing we often hear is that they're worried that what happens if down the road they get better and they want to go back to work and they've started a legal claim. The answers are actually quite simple. So first of all, most claims from the time we started are resolved within a year or less. It can take longer. I'm certainly not guaranteeing it's going to be done within a year, but it's our experience that more often than not, we get to mediation or resolve it sooner than mediation within a year. But let's say even within that year, let's say we start a claim and 4 or 5 months down the road, the client comes to us and says, I'm feeling better, but can I go back to work? I've got this legal claim. The answer very simply is yes, you can. As long as your doctor is saying that you are ready to attempt to go back to work, then there's no reason for you not to try. And in fact, if you're able to go back to work and you're successful, then you're in a much better position. If you are working, you keep 100% of your income. If you're getting a disability claim, even if they're paying you, you're usually only getting around 2/3 of that. So you're better off if you can go back to work. And if we've started a claim and you've been able to return to work in 4, 5, 6 months, then so be it. Your claim isn't going to continue beyond that. You're not going to be entitled to benefits beyond the point you successfully returned to work. But you have a claim for the period of time from when you were denied or cut off your benefits until you were successfully able to return to work. That is a finite claim for X number of months, but in fact, it's actually easier to resolve those claims because the exposure to the insurance company isn't as great, and they're much more willing to talk about it, and oftentimes you can get that resolved before even having to go to mediation with just a phone call. So it does not take a particularly long time to resolve, and you certainly are able to go back to work if your doctors are proving that you can return.
Sivan, what do you got this week to kick off?
Well, John, I had a lady email me about a case that I want to share with our viewers. So this is from a viewer in British Columbia. Remember, we do work all across BC and Ontario. And here's what she wrote. In 1989, my husband became disabled. He received long-term disability through his employer, but they kept cutting him off, indicating that they needed more information. Eventually, my husband was granted CPP disability. As the insurance company kept giving us problems by cutting off my husband's benefits, and I was taking care of my sick husband and 2 young children, we decided that it wasn't worth the headache to continue fighting. We decided to live on my wages and his CPP disability. Can you help my husband get what is owed to him based on his giving up fighting for LTD in 1989? What a tragic situation, but how common it is. Certainly we can't do anything at this point. There is a 2-year limitation period for starting legal claims in Ontario and BC, and frankly, throughout most of the country. And this is what we keep telling people, that if you've been cut off or denied long-term disability within the last 2 years, we can help you as long as you are disabled from working and your doctors support your disability. Now, in this particular case, we can't do anything, but consider the fact that he got CPP disability. The government deemed him disabled, which is a very difficult test to meet. And this is what I want our viewers to understand. Don't simply back out. Don't become a number for the insurance company, a statistic. Insurance companies are in the business of making a profit, and one of the ways that they make that profit is by keeping the money that is owed to you, legitimately owed to you, in their pockets. And they will do whatever they can to shake you off claim. And they will give you excuses, and we'll go through some of them. They'll call those reasons for why they're denying your disability, for why they're cutting you off. And most people assume that they have no rights. Most people assume that they can't do anything about that. Now, this lady is writing to me. This happened 30 years ago. Just imagine how much money for the last 30 years they have lost that the insurance company has kept, money that is legitimately owed to her husband. I mean, he's still on disability.
Easily hundreds of thousands, maybe
easily,
even
if not
millions.
more,
Yep.
maybe in the millions. Now multiply that by hundreds, if not thousands of claimants throughout the province. And again, that's a lot of money the insurance companies are keeping in their own pockets, money that is rightfully owed to these individuals. And we can help with that. So long as you contact us immediately, when you are denied, or if you've been told that you're going to get cut off, give us a call. Let us take a look at your case. It's free. It's going to cost you nothing to talk to us, for us to review your case, and we'll tell you. We'll tell you if you have a case. And if you don't have a case, like in this tragic situation, I can't help them. And I told her, we cannot help you because it's 30 years ago. But for other people, many others that contact us day in and day out, we can help, and we do help.
You know, we have many clients that have been denied their benefits where it's obvious that they are still disabled. Every doctor that they have seen has said they are not able to return to any job. We see this time and time again. This isn't true of everyone, but there are many people that we help that are in that position and are still denied by their insurance company the benefits. And they can't understand why. They say, how can it possibly be? It makes no sense. Everyone says I can't return to work. How are they cutting me off? Why are they doing that? And this is the answer. It's right here. This is hundreds of thousands, if not millions of dollars that the insurance company is saving in this particular situation and in many similar situations simply because the person was incorrectly cut off or denied their benefits, and this happened 30 years ago, and they would have had to pay those over the course of time. If X percentage does not challenge those claims, that's money that they just get to keep, and it's millions and millions of dollars. So that's why they are being unreasonable. That's why their decisions often defy logic.
The scary part is, I mean, for all intents and purposes, that could be a 30-year-old email. Nothing's changed.
Yeah.
Very little has changed since '89 to now. You get that email every day. That could have been written in '89. Nothing's changed.
Well, except that they didn't have email then. But other than that.
Yeah, right. Exactly.
No, but that's absolutely true. It's across the board, and it doesn't matter. You know, we get people contacting us not just from BC and Ontario, but from other provinces as well. Remember, these insurance companies operate throughout the country. Many of them are not just national insurance companies, but international insurance companies. They employ and use the exact same tactics across the board. And the goal for them is very, very simple. How do we keep your money in our pockets? That's what it comes. We're not talking about, the fraudulent claims, because those exist. We're not talking about people who, as James started out the segment, who can go back to work, and they do go back to work. That's fine. That we encourage that. But here you have a legitimate claimant, somebody who's still on disability from the government, and this insurance company, and I know their name, I'm not sharing it on air, but I know their name, and we've dealt with them quite a lot. They are keeping that money that is legitimately owed to that family. And so this lady, her disabled husband, and those two children that she was supporting all this time are deprived of this money that is legitimately owed to them, and no one is able to help them now because they're out of time.
Unlike that, we do have email now. You can reach out. It is simply help@inyourcorner.ca. We'll get to the first one of the day, guys. Amit writes in and says, I've been on LTD, long-term disability, for over a year. Recently, I noticed that someone's following me with a camera. I've been swimming twice a week as per my doctor's advice to release stress and anxiety. Should I stop doing this if the insurance company has hired a private investigator? What should I do if they stop paying me because of this?
Great question, Amit. I appreciate it. So I want to answer this first by discussing surveillance generally. And this is something that some people get concerned about, especially when they start a legal claim. They're worried that they're going to have someone following them. And it happens from time to time. I wouldn't say that if you start a legal claim, or even if you just apply for long-term disability benefits, that it's likely going to happen. But even if it does, in far more instances than not, it does not matter. And in some cases, the surveillance actually winds up helping. It winds up supporting the claim. It winds up revealing that your disability is in fact real, that you legitimately are not able to do all kinds of things that other people are able to do, and that you had been able to do in the past. So as long as you are truthful with your doctors, you're truthful anytime you're examined by a lawyer, and you stick to what your doctor recommends that you do, then you have absolutely nothing to worry about when it comes to surveillance. So getting to Amit's specific question, and just to recall here, he indicated that his doctor had told him that it would be helpful for him to go swimming on a regular basis. I'm not sure what his disability is, but that's something that would help. He says it'll help to reduce his stress and anxiety.
Doctor's orders.
Right, and so he's been going, and he's noticed an investigator filming him, which is bad form on the investigator's part. But putting that aside for a moment, he wants to know whether he should keep going. And the answer is absolutely yes. First of all, your doctor has recommended that you do this. So if, and frankly when, they try to use this as a basis for cutting off or denying your benefits, then it is very easy to dispute that if need be, in court. Because if it ever got that far and a judge saw that your doctor is saying you should be swimming, and that's the basis for them cutting you off, they'd be laughed out of court. It makes absolutely no sense. But the other side is also true, because if your doctor is telling you that you should be going swimming, but you stop doing that for whatever the reason, you stop doing that, guess what your insurance company is going to say?
You're not following your doctor's orders.
Exactly. They're going to say you had specific orders from your doctor, they recommended that you go swimming, you're not doing that, you're not trying to get better, we're cutting you off. So you're really damned either way, and if that's the case, follow your doctor's orders. If your doctor is saying that you should be swimming or taking medications or involving yourself in any kind of activity because that's going to be helpful for your recovery, do that. Do that. Try your best to get better. That's the best thing that you can do.
As mentioned off the top 5 excuses or reasons insurers give for denying claims and what you should do about it. That's coming up as soon as we come back from a short break. Reaching out, 1-855-821-5900 and help at inyourcorner.ca. Stick around. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to In Your Corner, inyourcorner.ca to find past shows and where you can catch our radio show as well, guys. As promised off the top 5 reasons, or we call them excuses, insurers give for denying claims and what you should do about them. Number 1, we'll get right into it. You're not, you love this one, totally disabled.
Well, you know what? That's probably one of the more common excuses that we find insurance companies denying legitimate claims for. And you know, what I think is confusing for people is the word totally. Because when you say totally disabled, and by the way, not just for claimants, but for their doctors as well, you say totally disabled, you're thinking catatonic, paralyzed. You know, you cannot, you have a brain injury and you can't get out of bed and
Feed
do anything.
yourself, can't dress yourself, can't do
That is not the test. The test is, can you do your own occupation for the first 2 years? Can you do significant portions of your own occupation so that you can earn, let's say, 60% of your income? And beyond the 2-year mark is, can you do any occupation for which you have training, education, or experience? And as long as you have somebody that's treating you, whether it's a family doctor, a psychologist, an orthopedic surgeon, someone who has been taking care of you, who says you are disabled from performing your occupation or any occupation, depending on when you are within that LTD world, timeline, then you should qualify. But again, insurance companies, I think, on purpose, intentionally want you to misunderstand that term. And so you get that letter that says you are not totally disabled, and so therefore you don't qualify for LTD. And in the vast majority of cases that we see when people come to us and they give us letters from their doctors that are explicit, that say this person cannot do their occupation or any occupation because of their disability, insurance companies deny those claims and people think to themselves, yeah, maybe that's legitimate. And they've only contacted us because they thought, well, let's see. Maybe there's something we can do here. And we look at the documents and we tell them, yeah, you have a case. You have a case. And lo and behold, we start the legal claim and the defenses fall. And the insurance company at some point early on is interested in trying to resolve the claim, and they come to the table and they try to negotiate with us. You know, negotiate with us that case that they've just denied a few weeks or a few months before on the basis that you are not totally disabled. Suddenly you are totally disabled.
James, that term totally disabled, have I not done this show and radio show for several years with you guys, I'm not totally disabled. I got no shot. They're right.
Yeah, no, I
scare away everybody.
Sivan's exactly right. It's worded that way intentionally.
Right.
They want you to misunderstand what it means. It means Nothing more than what is said in the policy when you look under the definitions page. It just means that you're not able to do your job. That's what it means.
Top 5 excuses insurers give for denying your claims. Number 2, and you guys read this one all the time, again, insufficient medical documents supporting your disability.
Yeah, I see this probably more than any other excuse.
Right.
It's so vague that it really doesn't have much meaning. When I see that, I read that as saying the insurance company is saying to you, I just don't want to pay you benefits anymore. That's the way that I read that. Now, having said that, there are steps that you can do to delegitimize that assertion from the start. So one thing that you can do if they're suggesting that they don't have enough medical documents is in writing, specifically ask them, okay, what documents do you require that I haven't given you? And have them set those out in writing, and then follow up with your doctors to make sure they deliver them. One thing that you may not know is that you're generally responsible for paying for whatever the costs are associated with getting those documents. So make sure that you've done that. More often than not, there's going to be some nominal fee associated with copying your doctor's file. Make sure that that's been paid for, especially if your insurance company is telling you that they won't pay for it. Make sure that you dot your I's, cross your T's, talk to your doctors, make sure they send the file, make sure that they've been paid for whatever the copying charge is, so that your insurance company can't then tell you, oh, well, we never got that, there wasn't sufficient documentation.
You know, John, this actually reminds me, this particular excuse, of a recent case that one of our associates at our office is handling. And he came back to the office after having an opportunity to question the claims adjuster who denied the claim. And he had asked her under oath, did you review all of the medical documents that had been submitted to you before we were retained, just before you denied the claim? And she said yes.
Oh, yeah.
So he pulls up the family doctor's handwritten records, which in many instances are completely illegible, and he asks her under oath in the presence of the insurance lawyer to start reading those to him. And she can't. And then she admits, no, you know what? I got those records, I looked at them, but I didn't really know what they said because they're illegible. And this highlights something for you. You may have provided sufficient medical documentation, but perhaps they did not review them, perhaps they did not read them, perhaps they did not interpret them correctly. So, again, this mismatch for people who are thinking, well, perhaps I just don't have enough documentation supporting my claim. No, that's probably not the case. If your doctors have said that you are disabled from working, then you've provided sufficient medical documentation.
We are talking about the top 5 excuses insurers give for denying your claim. Number 3 is there's no formal diagnosis for your disability.
Again, that's something that I have seen. It's not as common as the other one, the other ones we just talked about, but it's still, I still see it. And a case comes to mind about a lady, and this was a couple years back. She was a fairly young lady, and suddenly she started having these cognitive issues, memory lapses, and she was blacking out. And at some point, she had to move in with her mother. She was in the IT sector. She was very independent before, but slowly, progressively became dependent on her mother, couldn't go to work. And the neurologists that were examining her, and she went, I think, to over 10, they all agreed that she had these symptoms and these impairments, and there's no way that she can work. She couldn't even drive herself. But they couldn't figure out what the issue was. And she was sent for MRIs, CT scans, everything you can imagine, and they still didn't know what was wrong. And so the investigations were continuing. In the meantime, she applied for LTD, and her insurance company denies her claim on the basis that there is no diagnosis. We don't know what's wrong with her. They're not saying that we disagree with the doctors, that she can't work. They're simply saying there's no diagnosis. And of course, we look at the policy, there's nothing about diagnosis. The issue is whether or not you are disabled from working. So again, she's told, your case is worth 0. We are denying your claim because there's no diagnosis. We started a legal claim. Within just over 6 months, we found ourselves at a mediation, me, my client, the insurance company adjuster, a different one, not the one who denied in the first place, and a very senior defense lawyer. And we settled that case for a good chunk of money. I can tell you, it was in the low to mid 6 figures.
Wow.
And that's a claim that only 6 months before they had denied outright. So again, if the insurance company is denying your claim because they're saying, well, we can just, there's no diagnosis, we have no idea what's wrong with you, that's very different than taking the position that you're not disabled from working. That is the test.
So, James, doesn't that mean if there's nowhere in the policy that says there's nowhere that diagnosis has to be mentioned, now it's based on symptoms?
It is, and it's not just a matter of saying it doesn't say that in the policy. In fact, our Supreme Court, the Supreme Court of Canada, has said this very clearly, The analysis is not about a diagnosis. It is about your symptoms. It's clear as day. And so when I see that in an insurance file, I know that they have no leg to stand on, because they're not entitled to deny benefits just because they haven't been able to find a label for the collection of symptoms that you're suffering from. And we all understand that medical science advances year over year, and we may understand 10 years from now something we don't understand now.
Yep.
But that doesn't mean that you're not legitimately suffering today. So it is very clear. It does not require a diagnosis. It is just a matter of whether or not you're disabled from returning to your occupation.
Excuse number 4 for your denial is this: you can do another job.
Sure, and so this gets back to what we refer to as the change of definition. Well, what do we mean by that? You're entitled to your benefits as long as you meet the definition of total disability under the policy. But that definition changes after you've been receiving benefits for 2 years. The first 2 years, you're entitled to benefits if you can't return to your own occupation. After those 2 years, you're entitled to benefits if you cannot do any occupation that you're qualified to do by training, education, or experience. And so when you're approaching the 2-year mark, very often we will see insurance companies start to do tests, send you to see people to see whether or not you're qualified to do other jobs. They'll do something called a transferable skills analysis, where they'll have someone look at your education, look at your work history, and then ask you some questions and figure out what your aptitudes are, and then say, okay, you can do this job, this job, this job, this job, or this job, based on what your medical condition is.
Yep.
Now, often it is based on a very faulty foundation. Often the medical information they're using is taken directly from the adjuster and is not a complete picture, and they haven't actually even looked at the medical records. I see that all the time. But oftentimes, it is very questionable whether or not the jobs that they're suggesting you're able to do are things that you'd be qualified to do. And then you take it a step further, because most policies are silent on this, but some policies will say, once you've reached that 2-year mark and you're after this change of definition, you are still entitled to your benefits if you are not able to do a job that will pay you at least X% of your income before you went on disability. Sometimes it's specified and they'll say 50%, 60%, 65%. If it is specified, then that will be what the test is. So those jobs that they're suggesting you can do have to meet that test. So if they're saying that you can do a job, but it's only going to pay you 30% of what you were making before, they're still required to pay your benefits. But if your policy is silent on that, the law says that you have to be able to do an occupation that will pay you commensurate earnings. And typically that means around 60% or so of what you had been making before. So if you are earning a significant income before you go on disability, and then they're saying to you, well, okay, you can do this minimum wage job, and therefore you are no longer entitled to your benefits, that's just simply untrue. There is a test that they have to pass, and that would not pass it.
The top 5 excuses insurers give for denying claims. The last one is the one you guys like to dance around a lot, and that is you don't qualify because of a pre-existing condition.
And that's something that we see quite a lot, exactly. And I mean, we have to treat that kind of a denial, that basis, on a case-by-case basis, really. And the reason is because oftentimes I see that exclusion misapplied in the policy. I'll have, for example, a client who had a heart attack, and as a result, that person can't work. And the insurance company says, well, he had high blood pressure, which caused the heart attack. And so therefore, because the high blood pressure was something he had before he went on the policy, therefore he doesn't qualify. It was a pre-existing condition. Or you see that with diabetes and ulcers, for example. The person had diabetes before for many years, but then is unable to work because of foot ulcers, which sometimes are caused as a result of diabetes, but not always. So, again, we have to look at every case individually. Generally, when you have these exclusions, they typically are written in a way that says, have you seen a doctor for that condition in the 90 days, preceding the disability or preceding you being on benefits? Have you received any treatments? Again, we have to look at every case. The message here, I think, for people is that if you are denied on that basis or any of the bases that we talked about, don't take it at face value. Don't assume the insurance company is correct. Check with us. We'll be able to tell you, and we'll tell you if we think that they are correct, because in some instances they are correct, right? It's not like every claim they deny falsely, but in many, many instances, people have a gut sense. They know, their own doctors know that the insurance company's position is unreasonable, untenable at law, and should be challenged. And that's what we are here for, to help people make that decision and to give them options if in fact that's the case.
All right, guys, we'll take a short break and get right back at it. 1-855-821-5900, the number to reach out. Email is help@inyourcorner.ca. This is In Your Corner. We'll be right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Hey, and welcome back to In Your Corner. James Fireman, Sivan, Tumarkin, John Scholes, mydisabilityquestions.com. That is a great resource for you to ask questions. It's been around for quite a while, the website, and these guys will answer those questions very quickly. There's a good chance that your question has been asked or at least answered in depth, so check the drop-down menu for sure before you ask yours. If not, go ahead, fire away. Ellie writes in from mydisabilityquestions.com, says, my husband got a call from his employer telling him that they don't want to continue paying long-term disability. They will be cutting him off in July. We've dealt with an insurance company up till now, so we're not sure why his employer is calling about this. Who should be dealing with us about this? Can his employer decide to cut off his insurance payments?
This is a pretty interesting question, and we see this a lot of times where someone is employed by a larger employer. And in those circumstances, not always, but sometimes, what they'll do is instead of just buying a policy that covers all of their employees, they'll actually fund the policy. So what I mean by that is they're not going to be paying an insurance company premiums. They're just going to self-insure their employees and pay the benefits themselves. But because these employers are not really in the business of adjudicating insurance claims, they'll hire an insurance company to do what's called administrative services. And so essentially the insurance company is doing the same process they would do if they were insuring that policy, but they're doing it on behalf of the employer. And even though the insurance company is going to give their recommendations, it's actually the employer's decision. Now, the reality of that relationship is that far more often than not, the recommendation of the insurance company is what's accepted, and it's mostly seen as a rubber stamp. But the employer can certainly get into some trouble if they start overruling that, especially against what the insurance company is telling them. So this appears to be what's happening. I would need to see the file to be sure. But it seems as though the employer has decided to cut off the benefits, perhaps on the advice of the insurance company, perhaps not, and now they're saying, okay, now you have to come back. Now this can create an issue, especially if the insurance company has advised them that the person is still entitled, because as the employer, they have a separate relationship with their employee. And so if it winds up that they're forcing them to come back to work when they are not ready to do so, when they are still disabled, they're also opening themselves up to human rights damages, which can be significant and is not offset by the disability policy, and that is really big.
Yeah, no, it's 100% correct. I mean, you are dealing with a situation where you may have employment issues and disability issues, which again, we have employment and disability lawyers. We work together to maximize the compensation for our clients.
Again, anytime you can use mydisabilityquestions.com like Ellie did, or you can write through an email, help@inyourcorner.ca. The phone number is also always good, 1-855-821-5900. And the website itself, inyourcorner.ca. You can find past shows and our radio shows as well. We will join you once again next time right here on In Your Corner.